What does an argument mean for you?
Nah, we were just arguing. Like, we didn't do anything crazy. She just ripped my shirt.
Your back says otherwise. Your back and your neck is destroyed. Why do you have so many scratch marks on your back? Here, stand up. I'll take a picture and show you. Like, you're like bleeding everywhere, dude.
Anything that's domestic violence related, especially when there's visible injuries, we have no choice. There is no wiggling. There's no wiggle room for that.
Hello.
Hey.
Where are they at?
There. So the car.
Oh, near the trailer?
Yeah, in between the trailer and the van.
Okay.
It's like a little Toyota Corolla.
Okay.
I don't know. Like I said, they weren't, besides being loud and obnoxious, and a tenant from another unit stopped at my office to let me know that there was a little cray-cray going on. And
they're just being loud.
She just kept screaming, I don't know what your problem is. And like I said, at one point, the guy's shirt, he had one arm in and one arm wasn't in, and then there was a dog and the dog was running around a little bit, but they got the dog in. And then now another guy just showed up and he put his arm around the girl and made the other guy get in the back seat. So I don't know what's going on, but I just
sure, we'll check it out.
Just check it out for me, please.
Alrighty. Okay.
On March 14th, 2024, Lee County Sheriff's Office deputies responded to a reported domestic disturbance at a commercial parking lot in Florida. What began as a welfare check became a criminal investigation. The moment deputies observed visible injuries on one of the parties, Florida law removed the officer's discretion from that point forward.
Sure? Okay, you want to come out and talk to us? Yeah, what is it?
Just relax and I pause the witnesses.
Aggressor 5 Charlie 3, 65 a signal for possible injury.
What happened?
Come here.
J51 to 6 Mile Cypress and Michael G. Rip.
I'm talking. You got any weapons on you?
Yeah, just
Gonna be just past Michael G. Rip.
Anything else?
no, shit, sir.
What's going on, man?
Nothing much. Just I got into a little
Gonna be
argument.
an Acura versus another vehicle with airbag.
What does an argument mean for you?
Nah, we were just arguing. Like, we didn't do anything crazy. She
Your
just ripped my shirt.
back says otherwise. Your back and your neck is destroyed.
When she ripped my shirt, I tripped on my shoes. And
Who is she to you?
My wife.
Your wife. How long you guys been together?
A number of things, and it's ruined my trust for her.
Okay.
And today I found out she had, like, I was, like, asking to go through her pictures.
Yeah.
And she finally showed me. And then when I see something, I'm like, what's that? She had a Ziploc baggie with pills in there. She keeps saying it's Plan B. But if it was Plan B, it would come in a little container that says Plan B.
Okay.
Not in a sketchy Ziploc bag. Then she has other nudes on her phone. So then I'm just like, you know what? I'm going to go back to work. And she pulled my shirt.
Why do you have so many scratch marks on your back? Here, stand up. I'll take a picture and show you. Like, you're like bleeding everywhere, dude.
I don't know, so...
It's not crazy, you know, like, coming out, but look. All that, man. That's blood from getting smeared. And you got blood on your hand. Too. Oh. Was it physical? Like, did you try to defend yourself at all, or hit her or anything like that?
I'm just trying to get away from this situation. I'm trying to get her to just leave my life because she's lied too much.
Okay.
She currently has my keys to my house right now.
Do you guys live together or no?
Yeah.
Okay.
Relax.
Aggressor 5 Charlie 3, 65 a signal for possible injury.
So what happened?
J51 to 6 Mile Cypress and Michael G. Rip. It's gonna be just past Michael G. Rip.
Behind me.
What's that?
It's gonna be an Acura versus another vehicle with airbags deployed.
What's that?
1406.
It's all right. Just take a deep breath. All right. So just tell me what happened.
Oh, he wanted to check my phone, and then I told him to don't. Then
he got mad at me because I got some pictures of my legs. And then he started calling me cheater because of that. And that would happen, but I don't want him to have problems.
Okay. All right. Did anybody hit each other?
Oh, when he was trying to run away with my phone, I just pulled him by the t-shirt because he broke it.
Okay.
And then
Okay. No punching, no kicking.
No punching.
Did you see anything?
No, I'm his father.
Oh.
That's the father.
Yeah.
He's just like a daughter. And just came like, want to calm down, but you guys came.
Yeah.
Okay.
Okay. Do you know anything about the laws in Florida for
For
domestic violence?
No, sir.
Okay. You're telling my partner that you got physical with your other half because of the phone and stuff like that?
Yes, sir.
Okay. All right. What happened to your phone?
He tried to take it from me, and then I told him to don't take it from me.
Mm-hmm.
No, it's not
Yep.
my fault, sir.
Under Florida Statute, Section 741.2901, Subdivision 2, when a law enforcement officer responds to a domestic violence complaint and observes visible injuries on a party, arrest is mandatory. The statute does not allow the officer to weigh the victim's preferences. It does not allow negotiation. It does not allow the parties to walk away. Probable cause plus visible injuries equals a mandatory arrest. The probable cause determination here was grounded in 3 independent pillars. First, physical evidence. The male subject's back and neck bore extensive scratch wounds, consistent with fingernail lacerations. The female subject had visible blood confirmed beneath her fingernails. Physical evidence that links a suspect's body to a victim's wounds is among the most reliable categories of probable cause evidence available. Second, the female subject's own admission. She acknowledged grabbing the male subject's shirt. Under Florida Statute Section 784.03, battery requires only intentional physical contact against another person's will. Her admission satisfied that element. Provocation is not a legal defense to battery, absent an imminent threat of physical harm, which was not alleged. Third, independent witness corroboration. The stepfather, who arrived separately, confirmed the couple had been arguing and fighting his own words. Under the totality of circumstances standard established in Illinois v. Gates, 462 U.S. 213, 1983, this combination of physical, testimonial, and corroborative evidence clearly meets the probable cause threshold required for a lawful arrest.
Come on, put your hands behind your back. Hands behind your back.
Sir, it's not my
I know.
Why you taking me, sir?
For DV battery.
What is that? And he?
Because you scratched him.
But he bite my hand,
Okay,
sir.
we're
And
listening.
he gave me a 2 eyes last week.
Oh,
Why you have to?
Okay, we're listening. You're being detained for the investigation, but we're listening to what you have to say. Okay?
sir.
Yes.
We have probable cause for domestic violence, so you're being detained. Okay?
Okay, sir. I don't know my father's number because my phone is broke.
Your phone number?
Yeah.
Okay.
So you're gonna take your phone with you into the jail, okay?
What is broke?
What's that?
Why is he taking me?
Did you witness any of it?
No, nothing.
Okay.
Like, most of the
Okay.
reason basically to arrest them kids, basically, they are newly
Huh?
married. I'm a stepfather.
Okay.
Right? Right. I have no idea what's going on. Like, I called him, basically, he worked for me, right? I have a business here. So he was on the break. So I said, what's going on? It's almost break time done. So he said, can you please come? They was basically arguing and arguing, I believe. So, right? So after that, I don't know. You guys came and I came like 2 minutes before. So I even don't know basically what's going on.
Okay.
Right? Newly husband and wife, the relation have it's tough basically. It is start. So what happened, I don't know. But I don't know what was the reason to arrest her, if you don't mind. Can I ask?
I mean, he's welcome to fill you in, but the stories were consistent and it shows her as a primary aggressor. So in the state of Florida, we have a duty to act, but we're still gathering the stories.
Yeah, what I understand today, frankly, they are newly understand. They have, trust issues with each other. Newly married, it's not like they know them for a long, long time. It's like 4, 5, 6 months ago, and they just married. I have no idea why the hell he did it. You need to involve the families because it's not like when the kids don't involve the family, of course, these kind of things happen. I don't think so. I met with her first time, and I don't think so. She's a bad girl.
No.
I feel bad right now. She's in basically in the car. But this anyway, this resolved basically like you guys think so, or she is arrested.
Anything that's domestic violence related, especially when there's visible injuries, we have no choice. There is no there's no wiggle room for that.
Florida Statute Section 741.29, Subdivision 4, explicitly states that a victim's desire not to prosecute does not control the officer's decision to make an arrest. This provision exists because the legislature recognized a documented pattern. Domestic violence victims frequently recant due to financial dependence, fear of retaliation, emotional attachment, or external pressure from third parties. Placing the arrest decision in the officer's hands, rather than the victim's, was a deliberate legislative response to this pattern. The charging decision, however, belongs to the state attorney's office, not the officer and not the victim. Florida's no-drop prosecution framework allows the state to proceed even without victim cooperation, using physical evidence and prior statements made at the scene. The female subject's post-arrest claim that the male subject had bitten her hand and had struck her on a prior occasion introduces the concept of mutual combat and cross-allegations in domestic violence cases. Florida Statute Section 741.2901, Subdivision 2, requires the officer to identify the primary aggressor, not simply the first person to make a complaint. The statute directs officers to consider comparative severity of injuries, offensive versus defensive wound patterns, and any history of prior domestic incidents. The scratch wounds on the male subject's back, consistent with someone being grabbed from behind while attempting to flee, represent a classic defensive wound pattern. The female subject's unverified counterclaims, raised only after arrest was announced, carried significantly less evidentiary weight in the field determination.
No discretion.
Is it because of me or because of her?
You have visible injuries on you.
It's because of both of your
Like,
statements.
she didn't do it.
Did not touch anything. I think you can see
Like
her
I felt
face.
she grabbed my shirt.
So let me ask you, why is there blood underneath her fingernails?
Because I don't understand, sir. This is a small little
So
space
to be
right
frankly,
here.
I can justify you as well.
My pants are pretty
In her
baggy,
car,
man.
have a
This
glass
is-
bottle broken, right? Maybe she was like, angry person. They messed up. I don't know. I did not saw it. But
But she
first
didn't do
thing I
anything
asked,
to this.
did you guys
It's
hate
not what
each
you
other?
said before.
No, like I even told you I tripped. Only
I heard that,
she spoke.
but that's not what you said. That's not what you were saying. She has visible blood under her fingernails. You have scratch marks on the back of your neck. It's not from a bottle. It's from her fingernails digging into you. And you said you were trying to get away, which is consistent with it being on your back and not on the front of you.
Listen, it's going to be up to you whether if you want to go for. She's going to go to jail for the day, at least.
Is there any way we can?
If you choose not to press charges, not to show up, then it's going to get dropped, and it's
Can
not.
we just forget about all this and just go on?
No, when it's DV, there is no forgetting about it.
What happened with the phone? Why is this phone smashed?
All right.
Tell me the story about she was mentioned that you tried to grab the phone. What's
Because
this?
I saw the pictures of the sketchy pills on her phone.
So then, how did they end up?
Why is it smashed? Yeah.
I don't know.
And the screen protector's on the ground. I'm assuming belongs to that. Maybe the lanyard. Did you take it and you got mad and you threw it down?
I don't understand what just happened. All I know, I was trying to go back to work.
When you're aggressive, you do so many things. And
Okay.
Let's
Let's go talk over there because he didn't witness it and he's trying to influence my investigation. She's claiming that you're the primary aggressor in this, and that she's innocent.
I was at work. She came to see me to have lunch with her.
Uh-huh.
That's it, sir. Like,
Do you guys have prior domestic incidences? Because she's claiming she's gotten punched in the eye before.
no,
I don't know when that was, if it was recent.
I've never done that.
Okay.
But
So how do you explain the phone getting smashed? Huh?
I have no explanation for that.
So how did it happen? You were here.
I don't know, sir. Like, I'm the one that's like got marks on my back. I didn't even know it was.
You got marks on your back, but
You're
you're
saying that it was
you just
her, but-
no. You got marks on your back.
Yeah.
I'm asking you about the phone, and you're saying it's from that. I'm telling you it's from her, and now you're saying it's from her.
No, you said it's from
100%.
Okay, so then I can't argue with you. But I don't understand about.
Now for the grades. The lead deputy receives a B+. The mandatory arrest decision was legally correct, the party separation was proper, and the intervention when the stepfather attempted to influence the investigation reflected sound witness management. However, when an inconsistency emerged in the male subject's account, it was noted verbally but not formally documented on camera for the case record. In domestic violence prosecutions, on-scene documentation of inconsistencies becomes critical when a victim recants and the state proceeds without cooperation. The female subject receives a C. Her admission to intentional physical contact, combined with physical evidence, placing her as the aggressor, satisfied the battery threshold by her own words. Raising prior abuse allegations only after to arrest was announced was tactically ineffective and procedurally late. Those allegations required independent investigation through proper channels, not street-level objection. The male subject receives a B. His cooperation and physical evidence were consistent with a primary victim narrative. However, his minor inconsistency regarding the origin of his wounds and his introduction of unrelated collateral matters unnecessarily complicated the investigative interview. The stepfather receives a B-. His contextual information was corroborative. His attempt to speak near the investigation area, however, crossed into witness contamination territory that required deputy intervention. 3 lessons from this encounter. 1. An admission is an admission. Suspects who describe their own conduct without understanding the legal elements of the offense they are describing frequently provide the clearest probable cause available at the scene. 2. Physical evidence speaks independently of witness credibility. Blood under fingernails does not recant. Scratch wounds on a back do not change their story. In cases where witnesses become unavailable or accounts shift, physical evidence documented at the scene becomes the foundation of the prosecution. 3. Mandatory arrest laws exist precisely for situations where parties would prefer the law looked the other way. The presence of visible injuries removes the discretion that compassion or social pressure might otherwise exploit. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.